Good morning, everyone. This is ERD case number CR 2021-01845. It is Monday, March 6, 2023. This is the case involving James Lucky versus Milwaukee County. Hearing is being held via WebEx. It is day 4 of a multi-day hearing. Could I have the appearances, please?
Sure. Ben Hitchcock Cross, Cross Law Firm, appearing for and with the complainant, Mr. James Lucky Jr.
Thank you.
Good morning, Your Honor. Melinda on behalf of Milwaukee County.
All right, and it looks like we have Rhonda Rogers, who's a paralegal for Milwaukee County. Is that correct?
That is
correct,
Your Honor.
And then we have Portia and Tiffany. And can someone explain to me who those individuals are?
I assume they're public observers. I believe Dr. Keith is also going to come in as a public observer.
Okay. All right, so I would like to start by asking Mr. Hitchcock Cross what he intends to do today in terms of presenting his case.
Sure. So I'm going to have a number of motions and other things I'll need to get on the record here first. As we all know, I was intending to recall many of the county's witnesses today and going on with the rest of our witnesses from there. I understood because you had told us to confer at the end of the last hearing, so I tried to do that. The county, Miss Melinda Lawrence, refused to talk with me over the telephone in any capacity whatsoever, so we did that by email. She emailed us, meaning the tribunal and myself, stating that she was not available as counsel for the county for hearings and that there were certain witnesses that would not be available this week. As far as I know, that was Miss Byer on one day and another individual after that. We asked them at that time, and this is February 11th of this year, why they were not available on the 8th or 9th. We asked them when Novotny, Smoot, Molly, Ball, and Paul would all be available. They never responded in any capacity whatsoever, except they sent an email to you. It was not clear that it was some kind of motion or anything else, but they said that they were seeking clarity. So at which point we responded and clarified again that it was only 2 witnesses out of a substantial number of witnesses that needed to be recalled and called that are on our witness list that weren't available. And so therefore the county was trying not to have any days, any hearing today. We never got a response back from the county nor the tribunal on that issue in any fashion whatsoever until Friday late in the afternoon. At which time the tribunal assumed some facts that were not in evidence. So, for example, at that time, the tribunal said, this is at 4 o'clock in the afternoon, so approximately 1 business hour before now. The tribunal said, I believe it's been known by all of us since February 3rd that the county's witnesses were not available March 6th and 8th with the exception of Byers, who was as of February 6th available on March 8th, when it was stated that you would be allowed to recall witnesses as necessary. It was understood that you would work with the county far enough in advance to assure specific witnesses' availability. And then the tribunal said, I am not ordering the respondent to produce Zillig or Novotny. You can move forward with your case on Monday, is what the tribunal said. So again, to be clear, that the facts there, as stated by the tribunal, because again, and we're going to hear this a lot today, the basic definition of a judge is to hear both sides. And when that doesn't happen, we're not even getting to that threshold of what we're here to do. So, again, the evidence that we had here and what I had brought to the tribunal was, see below, because I had asked Miss Lawrence here had refused to respond in any capacity whatsoever to my request for Ms. Zillig or Mr. Novotny or others, and for her to respond to my requests, and because she refused to talk on the telephone. So on Friday, the morning before the hearing, some business hours before, she says, "What witnesses would you like?" And then informs me, because it's clear that she had just asked them that time, that they were somehow not available. Even though it was clear to everybody back in January that these witnesses were going to have to be recalled because the county did not produce documents that they were required to produce and discover. So, and this is going to be another theme that we're going to have here, because it goes to the tone and tenor. Every time the complainant, the employee, Mr. Lucky here, makes a move or a letter or otherwise communicates to the court, there's either no response at all or only a response when the county, that is Ms. Lawrence, responds. And in some cases, it's, less than 15 minutes. So it needs to be clear on the record about the tone and tenor of these proceedings here and of what's happened here in the meantime, where there seems to be a clear one set of rules for Mr. Lucky, the employee, who's paying to be here, and another set of rules for the county. And again, the county seems to be dictating the course of these proceedings here, because when we ask for some sort of relief, not only is the relief not even discussed, or the fact that we've asked for it, but the facts that we seem to put into the record there are either ignored or the opposite is taken as fact. So when we get in again to Ms. Byers and what was supposed to be happening today, it was clear from the record and from what the county produced that only Ms. Byers and another witness were not available. Again, that left a substantial number of their witnesses that were yet to be called, as they knew, and Mr. Novotny, Ms. Zillig, who you've now refused to have come show today. That also left Ms. Paul, who needed to be recalled, the sheriff, who needed to be recalled, and so forth. We all knew that back on February 11th. The county just didn't bother to respond. So that, I think, is the factual situation that's leading up to this question here of what it is that we're supposed to do today. I'd like to just go back a little bit further here, because again, when we went to the county and told them what our intention and for witnesses was and how we intended to have this hearing continue, because basically, remember, one of the reasons that we're having this hearing continue is because the county did not produce documents that they were required to produce on a discovery. But given that fact, for some reason, they couldn't even bother to respond. Now, again, we're going to remind you that you ordered everybody to confer. I think it was very clear when I left here, and I took the burden on myself to go do that. And I also put those facts in front of you. So that's why I was extremely curious when I got a response saying, you, Mr. Hitchcock Cross, you, Mr. Lucky, should have gone to the county. Because not only did we go to the county not once but twice, and not only did the county not refuse, But then when you had that evidence that they didn't do that, there was no action taken, except to give the county what it wanted, not once, but twice, without the county ever doing what it was required to do first, according to the rules, which is to confer. So once you decided that there was going to be no depositions taken after you had ordered the reopening of discovery. Now, we'll get into that later, but again, that was, they didn't confer with us. They did not give you any evidence that they conferred with us. They filed no statement certifying that they had conferred with us, as is required by the record. Nonetheless, their request was answered within a matter of moments. Which again brings me to this opportunity to highlight the contradistinction here between the treatment of the tribunal, the tone and tenor here of these proceedings with respect to how the employer is being treated and how Mr. Lucky is being treated. Because they're quite evidently not the same. So, now again, with all of those facts in mind, we are being asked what we want to do. So, as I've said, we've put on the record what we want to do. We were very clear what we wanted to do back in February 11th when we all discussed this against the statute and the rules. Now, we were still clear yesterday, on Friday, after, though, I had to correct the record to be clear that, in fact, it was only Ms. Byers who was unavailable one day. And in fact, it was not true, as you stated, based on your reasoning, that Mr. Novotny wasn't available, Ms. Zillig wasn't available, and so forth. So when we then put that information back in front of the tribunal on Friday afternoon and asked the tribunal to reconsider, there was no response again, which is exactly the same tone and tenor as we've had throughout these proceedings. Yet, the tribunal, knowing that we have put this reconsideration and these facts in front of it, is now asking us again what we want to do. Which I'm taking that to mean here, and again, for the record, and so we're all clear on what that means, that we're being invited here to have Mr. Lucky testify now. And I think we've all been clear since the beginning that it's our intention to have the county's witnesses, the employees, testify first, so that Mr. Lucky can explain his truth after that. We all know that. So once again, we're all here. I'm here. Mr. Lucky's here on Mr. Lucky's dime. And we're being asked, what do we want to do? Just like we spent the third day sitting there, what do we want to do? The county's got some document that's vital to us. What do we want to do? Here we are again. It's not even, literally no time has passed from this hearing to another in terms of hearing time, except for we've had all these communications here, and all they do is strengthen the case for that we're going to have to eventually make to Lurk on tone and tenor. And the fact here that Mr. Lucky seems to be getting a different set of rules applied to him than the county. So what are we doing here is we're sitting here waiting. We're expecting Mr. Novotny, Ms. Zillig, Ms. Ball, all the other people that we listed on the 11th to be appearing here ready to go. We're also expecting all the people that we've already subpoenaed to be here ready to go. So again, when we had the courtesy to then go say, we already gave them notice that we wanted all of these people here ready to go. We told her yesterday on Friday morning, that's the county, Miss Lawrence, that we expected to go when we were asked. We wanted Miss Zillig and Mr. Novotny to go first. So the response to that from both the court, or the tribunal, excuse me, and the county was nothing. We might say crickets. So a proper response might have been to, okay, Mr. Zillig, Ms. Zillig and Mr. Novotny are not available at these times. So what other witnesses have they offered to be available? Because the onus is not on us to just produce Mr. Lucky or call it a day. Because I'm still not clear on what you're asking us to do here, Judge.
I am asking Mr. Lucky to testify.
Right. And we're objecting and saying that's absolutely improper. I mean, that's just, I mean, beyond, that's okay. I appreciate you for getting that on the record here. Because that is a whole other thing in and of itself. And now I guess we're going to have to make another motion on that. So I think we're clear on where it's absolutely improper. And it's clear that you have the ability to control the course of a hearing. But Mr. Lucky also has the due process right to put on his case. And that's not what's going on here today. What's going on here is that there's one rule for Mr. Lucky and another rule for the county, and it's apparently because the tribunal wants Mr. Lucky to testify today. That's problematic.
Well, I find it difficult to address the issues in this case without hearing from Mr. Lucky himself and the treatment that he experienced in his, as expressed in his complaint. You know,
No
trying
doubt.
to get it in through the county's witnesses, it's not the same as hearing directly from Mr. Lucky himself.
That does not give the tribunal the right to dictate the order in which witnesses that we put on and the order in which we show our case. So no doubt that we're going to put Mr. Lucky on or not. That's up to us. The point here is that it's absolutely, it's not just improper, it's indicative of bias to sit here and tell us that we have the order in which we have to put Mr. Lucky on. We need, I mean, we want to put on people who we think are not telling the truth. We want them to be on first. Then we can have Mr. Lucky come on and tell the truth of what happened. Somebody who actually remembers the details, not just the convenient details. That's how we want to put on our case, Judge. And we're entitled to do that. And those statements in and of themselves are very problematic of the tone and tenor of these proceedings here. It's absolutely improper for the tribunal to dictate how we're going to put on our case.
Well, I disagree. I do not have any bias in this case. I do want to hear from Mr. Lucky because I did read his complaint, and I do want to hear about his experiences. And that, you know, helps me interpret what is being said by the respondent in terms of, you know, what happened afterwards. So I'm sorry that you think that there is some bias here against your client. That's certainly not true. I do very much want to hear from Mr. Lucky because of what he had put in his complaint.
Well, of course, Judge, but that's not answering the issue. That's answering a separate issue, which is whether or not Mr. Lucky should be heard. That's not the question here now. The question is what order should Mr. Lucky be heard? And,
Right.
Right.
And I have the authority to regulate the course of the hearing. And if we don't have witnesses available that you can call from the county, then it makes sense to have Mr. Lucky present his testimony.
Only when you take into account the fact that we have subpoenaed witnesses that should be here today right now that you have said that you weren't going to order to have them come. So when you take both of those facts in comparison, that's when you have the problem and the tone and tenor comes into play. Because but for, again, this statement, again, and we can just move on from Ms. Zillig and Mr. Novotny because there certainly are a whole host of other people who can respond to this. But that's not, it can be here today. But that's not what's happening. What's happening is the tribunal's indicated its preference not to hear from any more witnesses from the county, but to hear from Mr. Lucky. So that is a problematical statement indicating bias, for sure. So I understand that there's nothing we can do about that to go to Lurk, but we're going to have to get that on the record here because that's what the problem is. It's not the fact of whether or not we hear from Mr. Lucky, it's the order. That's what the issue, and there's absolutely our witnesses who are subpoenaed here today by the county to come, who could be here. So Miss Byers, for example, is available to be here and is subpoenaed now. She is not excused. Where is she? There are other. Miss Ball is also, the sheriff should be here now, is not here now. We also want to call back Miss Paul, given the fact that we have all these new documents. Let's bring in, if another person we could hear from is the county's IT person, because then we're going to get on to my motion about why we don't have the videos. But all of those people, just for example, are available to be heard, and that we went to the time, effort, and trouble to go subpoena them. And the only reason that we're not hearing from them now is because facts that you've made a ruling here based on facts that are inaccurate. And now that you've expressed your preference to have Mr. Lucky testify before more people from the county. Those statements are on the record, Judge. That's the problem.
Anything else, Attorney Hitchcock Cross?
On that issue, I mean, to be clear on that one, I think we've got to address I guess we'll have to go through on that. So, there are several kinds of bias. That one is bias that's on the record. Okay? When that is a statement there that is interfering with Mr. Lucky's ability to put on his case. That is the same as an a priori decision, which is what's happened here time and time again, on the facts. So without hearing any reason as to why, for example, Mr. Novotny or Ms. Zillig shouldn't be deposed, because you would assume that the tribunal would rather not have its time wasted and have them be deposed ahead of time so that we could have a more focused hearing. But instead now, everybody's got to pay the time and effort to have them come, and now we're going to have to ask them questions without the benefit of deposition. There was absolutely nothing on the record, no either fact or law, to base this argument here that we shouldn't be able to depose them. That is an a priori decision on discovery. Likewise, there have been other decisions since then to say that certain things are not related to Mary Paul's notes. There has been no attempt to hear from the complainant as to why those documents relate to Mary Paul's notes. That is no different than Brown or Bowen, and it's very clear that there's a decision. We've not been ever been afforded the chance since we got Ms. Paul's notes to state why the evidence that we need to seek is required and is relevant. We've never been given the chance to make an offer of proof. Instead, decisions have been made by this tribunal restricting our ability to get access to evidence. On another occasion, we have evidence here that there are documents from the county, videos of conferences between the HR person and Ms. Zillig. And I really need to highlight here that Ms. Zillig has no recollection of anything taking place there, except she recalls one thing, that she didn't push the record button. She can't recall it happening when we asked her about it, but she was able to swear under oath that she didn't push the record button. Well, guess what? In Teams, it records whether or not you push the record button or not. It's a policy that's set globally by IT administration. There was no effort to listen to that. There was no effort to find any facts. There was just, and to be clear, that's what our information said, was that the video was not deleted. They have not provided any evidence that says that it wasn't deleted. What they have provided was evidence saying that individual people didn't hit the record button beforehand. There was no attempt to listen to us. There was no attempt to listen to get more information, or in fact, when they offered to have their actual IT person come in and testify, that wasn't necessary. The evidence that we gave didn't say that somebody had pushed the record button or not pushed the record button. The evidence that we gave you said that the video had not been deleted. Now we'll go on to another issue. We were denied the ability to give other evidence, to get other evidence, I should say, on the theory that because, and then you copied and pasted this document, so we're all clear on this, that in response to a request for documents, they asked Mr. Lucky for a copy of his complaint, and he said that he didn't have one. Somehow, that turned a request for a production of documents into an admission. We were clear with that. We moved to reconsider. Once again, there was no response on that issue whatsoever. The county responds, and they get a response within 12 minutes. That's problematic. But okay, let's just go look at that issue in and of itself. When we are not given the opportunity to respond, and the decision is made simply out of hand based on an assertion of the opposing counsel, or when we had with the Miss Byers thing, we said that everybody was available and that we had conferred. And then the response was, well, since you didn't confer. But I'm sorry, to go back to this issue of taking a request for production of documents and turning that into an admission, that also ignores their responsibility to find all the documents. It also ignores the fact that the document was in the custody and control of the county. You know that because the county produced that document to you in live time. I didn't send that to you, Judge. The county sent it to you. You know that. You also knew it because we told you again in the motion to reconsider. So, again, the problem is that I'm listed off 3 or 4 things here where the facts that were either there's no facts to base a decision on, or when the facts come out, they're exactly the opposite of what have been relied on. And then when we correct the record, there's absolutely no response, which is in contradistinction to when Ms. Lawrence sends an email and the rush to respond could not be faster. So again, all of those things go to the tone and tenor because they're all examples of a priori discovery decisions, meaning it gives evidence that the tribunal is predisposed to a certain outcome on the evidence or of the decision because there's no attempt to hear from one side. So when that happens, and that's again, we're going to go back to our theme here today, the minimum definition of a judge is to hear from both sides. And that's not very much, but that hasn't happened here. And that's why we can say tone and tenor. There is on the record, there is just in the between these two hearings here, there are sufficient interactions and documented situations of violations of due process. I'll strike the situations. There are documented violations of due process because the judge has not heard from both sides and made a decision. Again, some of these decisions were made in violation of the requirement to confer before bringing these things to there, meaning the tribunal didn't even have the jurisdiction to hear those. So when we get into this thing here of saying, Mr. Lucky, the tribunal wants you to testify now, and then we'll go and hear from the other witnesses. That's another example of a decision, evidence that there's a decision made before the fact. Because of course the tribunal would want to hear from Mr. Lucky, but it's Mr. Lucky's choice if he wants to testify or not. They can call him, that's their absolute right or not. But for the tribunal to make statements saying that they want Mr. Lucky to testify here and now, when again, the tribunal has already ordered two witnesses who could have testified and were subpoenaed to be here to not show up, and is ignoring the fact that there's all these other witnesses that could and should be here because they're testified and are now subjecting themselves to civil liability for not being available. That is indicative of a decision-making before the fact. So you can say that you're not biased, but there's an analysis that needs to be done. And the problem is if we can identify these kinds of decisions that are being made in violation of due process, and they're on the record, then the result is required. So I think that's, as far as that motion goes there in terms of tone and tenor, that's what we have to say on that issue.
All right, anything else?
Yes, for sure. You just want to hear all my motions at once and then we'll hear response from the county, or how do you want to do that?
Yes, I would like to hear everything that you want to say now.
Okay. So in contradistinction to the county, we conferred with the county and filed with them a list of deficiencies in their discovery. They never responded because instead they went to you and said, we're not going to have any depositions. And again, in violation of the requirement to confer and for them to certify before filing a motion for a protective order, you granted a protective order in violation of the rule. I also, again, that was without hearing from us as well. And I need to, going back to that issue, I've counted, I think, 6 times now where the county has made a request or a motion from the beginning of this hearing till now where you have not even heard from the employee. And now, as soon as I get an email from them, I have to stop whatever I'm doing and rush to a computer to respond as quickly as I can. The last time I wasn't quick enough, you responded in 12 minutes. I'm only one person, Judge. I can't be everywhere at once. I can't be vigilant all of the time to know when there's going to be an email from the county so that to get there to at least have a chance to respond before a decision is made. So the motion for the protective order is granted. There's no reason stated for granting it. And we then file with you our list of discovery deficiencies. There's still no response on that. Where's our 12-minute response? So again, the statute is supposed to be that the county confers with us, we send discovery to them. If there's deficiency, we talk deficiency back and forth. And then we confer. After we confer, somebody is eligible to file a motion, but not until they sign a document stating when they confer and who they've conferred with. No such thing happened here. We objected to that issue. And a motion to reconsider. I think it's the third motion to reconsider that we filed here that has not been responded to. Again, 13 minutes for the county, infinity for Mr. Lucky. Any way you do that math, that's not fair. So that, I think, is the problem with the deficiencies here. Because, for example, we're getting responses like the request is after the period of retention, meaning that there's documents out there that they've destroyed because they haven't retained them. Well, we don't have a response on that. Let's go on. And this is, I want to be clear. On February 21st, I sent an email to opposing counsel saying, having not heard from you regarding your discovery deficiencies yet, and she had sent a letter to you. That was her email for clarity. Again, that's the one in which she didn't state that she had conferred with me because she hadn't. And then that the tribunal granted a motion in violation of the statute. So, yet you having sent a letter to the judge requesting a deadline extension, I am understanding that as a refusal to confer. If that is not the case, kindly contact me before the end of business today. Otherwise, I will assume that you are not conferring and will file the appropriate motion. So that's what's required in the statute, Judge. That's what I did. I conferred. Again, I tried to confer by telephone, as was required. And only before the ERD is that required, but that's what I did. She refused to talk with me. Okay. So then I emailed her. She refused to respond. Okay, but then she could respond to you. Okay, so then I called her out on it. She refused to respond again. That was the 21st. Here we are, it's the 6th of March. I still don't have a response, but I filed a motion with you. Didn't get a response. So when we get down to the fact here that when we're talking about discovery related to Miss Paul, and really the root of what's going on here, we have not been able to get to the heart of the matter, to the truth of the matter. We have had witnesses and facts withheld from us because the county just answers if they feel like answering. And if they don't, they go to you and without following the statutes, and they get what they want. And of course, having violated the statutes and gotten what they want, why would they respond to their discovery deficiencies? What possible reason would they have to follow the law. So they haven't, and yet here we are sitting here with a hearing, being told that we have to have Mr. Lucky go on, and we don't have all of the discovery to which we were entitled to, notwithstanding the order, protective order for Ms. Zillig and Mr. Novotny and Ms. Yu that was given contrary to the rules. So keeping those facts in mind here, we are again asking you to reconsider our motions to at least respond to them in some way. Denying them would be one thing, denying them for a reason would be another, but responding to the motions here and something like less than infinity would be appreciated here at this stage. And again, is indicative of the tone and tenor here, because again, although you've made statements saying you're busy and this is not the only case that you have, and we appreciate that, one only needs to look at the track record of the response, the time and response. And dividing by infinity makes it pretty easy. Mr. Lucky is a man. He is entitled to the protection of the Wisconsin Fair Employment Act. The Equal Rights Division is a body created by the state of Wisconsin to enforce the Wisconsin Fair Employment Act. I submit that that's not what's happened here today. And for this tribunal to ask this man to go ahead under these conditions is only further evidence of bias. Judge, I feel that we've communicated here.
All right, thank you. Ms. Lawrence, do you have anything you'd like to state?
Your Honor, I think for the most part, the record will speak for itself. I think Attorney Hitchcock Cross substantially misrepresents events that have occurred. I guess the two things that I would highlight are, one, that there are no subpoenas for witnesses for these hearing dates. These hearing dates were not confirmed until Friday, March 3rd. So certainly we had no opportunity to confirm anybody's appearance prior to that. We were directed by Your Honor to confer over those dates. That did not occur until Friday. I can't confirm witnesses for dates I don't know. As far as we're concerned, it's complainant's burden of proof. So what he does with his case is entirely up to him. With respect to the discovery, I think that we are not in violation. The whole point in the county conferring with Your Honor was to determine the valid scope of discovery. With the clarification, we believe that anything that we didn't respond to in the discovery was beyond that scope and therefore not viable discovery that the county needed to respond to. I don't think that there's anything that needs to happen here today. The county does not believe that there's any evidence of bias in this record, nor will the record demonstrate that. And the county sits ready for whatever the complainant wishes to pursue by way of his case today. Thank you.
Anything else, Attorney Hitchcock Cross?
Yes. So again, that's just not factually accurate. So as we read out on the record here, we had discussed with them several times now our requirement, and we discussed subpoenas at the end of the last hearing, but we also discussed with them who we wanted to appear. Because remember, they came up with the charade saying that we couldn't have any hearing dates this week because One person was not available the entire time, and another person was not be available for 1 day. So we called them out on that pretty quickly. And you can tell by body language. I mean, this is, yeah. I think we're all clear on that. So, when in fact, and I understand that you've got a lot going on, and so you may have misunderstood that, but that was clearly the case. Then, as we just read out here, we sent an email to them saying, okay, what about Mr. Novotny? What about Miss Sherrif Ball? What about Molly Zillick? What about Miss Paul? What about the other witnesses that we're trying to call back? And they didn't respond. So we do agree that you ordered the county and the complainant to confer. We disagree that there was conferment, because what happened was, I guess, conference, because we requested and responded to the county's what again is nonsense. I mean, they knew when they requested to you that one person not being available 1 day and another person not being available at all was no reason not to pencil this, to get this done. We responded on that issue. Again, you waited till today or Friday to set the hearing date invitation. We were clear on that we were ready to go forward. We were clear with the opposing counsel that we were ready to go forward. So the problem here is that the entire burden is being placed on Mr. Lucky, the person who should least has the cleanest hands here. And while the tribunal and the county are actually the reason for why the county has nobody ready to go today. And yet, once again, Mr. Lucky, the employee, the complainant, the black man, is being expected to clean up after everybody else. So that's the issue here. We conferred. We followed the law. The tribunal did not follow the law. The county did not follow the law. The tribunal is trying to make Mr. Lucky testify today. The county is trying to make Mr. Lucky testify today. That's wrong. That everybody knows, everybody here on this call right now knows that that's wrong.
All right. Well, I will not make Mr. Lucky testify today. If, I guess that would be inappropriate under the circumstances. If you believe that that's a violation of his due process rights, I'm not going to make him testify today. We did set aside time in May. So I would think between now and May 22nd, 23rd, 24th, we would be able to get some agreement on when individuals will be available to testify. I do not wish to take all 5 days that week, but if it takes, a couple days to get these individuals recalled and get Mr. Lucky's testimony, that's certainly understandable under the circumstances. I will respond in writing to your various motions. In the meantime.
Well, what about tomorrow and the next day, Judge?
Well, it doesn't appear that we have any witnesses.
Well, we've subpoenaed them and we have them. They're just apparently not agreeing to be here. I mean, we have witnesses. We have witnesses on our witness list. We've subpoenaed everybody on our witness list. They should be here. Then the people that we've recalled should also be here.
So you sent out subpoenas for these days, these 3 days?
No, we didn't re-subpoena everybody, and we discussed that in the last hearing. We didn't resubpoena everybody. No, we subpoenaed them in the first place. The people who were excused, you ordered to be recalled. They're also not available. Everybody who we haven't heard from is subpoenaed.
All right, Ms. Lawrence, can you just put on for the record why those individuals were not available for today?
Well, the only people we were asked to make available today was Molly Zillig and James Novotny. James Novotny is not at work today. He's taking personal time. I did not ask him what his personal time was for. I think given the short notice, I'm not required to. As for Ms. Zillig, she was not at work on Friday, so I did not have a chance to confer with her personally. What I did do is check her outward-facing schedule and saw that she was scheduled for meetings from 8 a.m. through 4 p.m. So I can't tell you what those meetings are. I just know that she's scheduled.
All right.
That is all I was asked for. Nobody else was subpoenaed. And if we need to get into Ms. Paul and Ms. Sheriff Ball, I think those need to be addressed separately. Thank you.
Okay. All right. So obviously, if the individuals are not available, then we can't have any testimony from them. And the same is true of Mr. Lucky if he wishes to not testify until after the county's witnesses are heard from as called by Attorney Hitchcock Cross, then I will respect that as well. I don't see this case moving forward until the 22nd of May. And I would hope between now and then we do have the ability to make sure that everybody that wants to be, that people want to have testify are available to do so.
Your Honor, if I may address that.
Yes.
Mr. Hitchcock Cross has repeatedly referenced Ms. Paul and Sheriff Ball. I believe with respect to Ms. Paul, he had hours on the record with her after the discovery of those notes to clarify whatever he wanted to clarify. I think calling her again would be duplicative and a waste of this tribunal's time. And as for Sheriff Ball, again, we objected to the subpoena in the first place because she's only involved in an administrative capacity based on paperwork, which is available in the record. So we objected that to her lack of personal knowledge. Your Honor overruled our objection and did allow her to testify on the record, which confirmed the county's argument that she doesn't have a personal recollection or personal knowledge of anything relating to Mr. Lucky's case. We would renew our objection to calling Sheriff Ball for those reasons. Ms. Zillig is similar. We had hours of testimony to which she's already testified. She has no personal recollection. She's, again, involved in an administrative capacity based on paperwork, which is in the record. I think recalling her is duplicative, unhelpful, a waste of this tribunal's time, and quite frankly, I think it comes down to harassment of county employees. We would object to all three of those being called. Captain Novotny, we have asked to recall him ourselves at some point later, so to the extent that we need to find a date to make him available, we will certainly do that. Those are the only witnesses, county witnesses I know of that complainant is seeking to produce. If there are others, we would ask that he state so on the record now so that it can be clear.
So I'll just address that there. So, because apparently it hasn't been understood. Hopefully it'll be understood this time. Just because during the last hearing, we discovered that the county had not produced documents that it should have produced, and that caused all the trouble, costs, and expenses that we're dealing with here now, does not mean that we were done with all of the other witnesses that we were intending to call. It was not our intention to talk to Ms. Paul for the entire third day. We had other witnesses that we wanted to talk to. There was not, by no means was that our intention. But as it happened, the county withheld documents. That issue on our not getting the discovery has already been cleared. Now, the only question that still is unresolved is, did they do it intentionally? We were already given the right to recall witnesses. So this here is a motion for reconsideration. Now, we have several documents that they have given to us. We have an outstanding motion to compel on all of the discovery deficiencies that they have not answered. So just in the documents that we have here that they've actually given to us, we have a significant number of questions to ask Ms. Zillig, who, as you recall, could not remember really substantial, even trivial issues about Mr. Lucky's disciplinary proceedings. So now we have 70, 80 pages of new documents with her name all over them, discussing with Ms. Paul, setting up meetings with Ms. Paul. And again, there's a video out there that would really render this case a lot simpler if we would just have the video. So, let's address that issue, please. And if need be, let's have some testimony from their IT person about what actually the recording policy is. Because as I've said before, they've put in our discovery responses that there's a document retention period, and that our requests were after the document retention period. Well, if they destroyed any evidence related to this case because of a failure to preserve that document, that's spoilage, and there's a significant problem here. So we've responded on that issue and put that issue in front of you, but we haven't got a response on that. So that's, again, the key question here, and we went over this before, because they're asking you to do analogous to what happened with Molly's, the motion for a protective order with regards to a deposition of Ms. Zillig. So at that time, they didn't say it was duplicative or anything else, and we weren't allowed to respond. But now that we've given the chance here, again, all roads led to Molly Zillig. It's absolutely clear that Mary Paul was getting orders directly from Molly Zillig, and that there is testimony time and time again that Ms. Zillig is the supervisor and final decision maker with regards to the Professional Standards Division. She just said something that was different than that. She said it before the hearing, then we had all this evidence, and you allowed us to have Ms. Zillig testify because it was clear that not only she was a supervisor, she was a decision maker. So we crossed that bridge, and now she's trying to again say something that's been clear based on the county's own testimony is not true. So that's problematic in and of itself. But in terms of the fact that Ms. Zillig is all over this, there we go. Now to Ms. Paul, again, there are numerous pages of information, as I sent you again, that you have in our response on why sanctions were appropriate here. Ms. Paul made several statements that were contradicted by the documents that we've either received on that day or have subsequently received. For example, she said several times that she didn't know about there was any communications with her and Ms. Zillig. She didn't recall that. She didn't know. Well, it turns out that there was numerous communications and numerous video meetings between the two of them and Mr. Novotny, all leading up to Mr. Lucky's immediate termination. In fact, some of them are occurring the day before. Ms. Paul testified she didn't know very much about his light duty restrictions. She sure as heck didn't know very much about him at all. But in fact, There's emails back and forth that we never got. And there's a meeting that took place that the video of it we submit still exists on light duty restrictions. And again, Miss Zillig, who was attended that meeting, doesn't remember anything about it, doesn't remember that it happened, doesn't remember anything. And Miss Paul said that it didn't. So we've got some fundamental issues to come back with these people on and to ask them why they made statements that are apparently false. That's why. That was at issue here in our entire motion for sanctions, because the whole issue of why all of these people have to come back, you know, she just accused of harassing county employees. But in fact, what happened was a county employee, oh, that absolutely reminds me. So there was a decision here that somehow Mr. Lucky failed to notify the county of his HR complaint because the respondent didn't know about it because the HR had it. And as if the HR of the county and the county are two separate things. As if they're not functioning as a corporation. And as if Ms. Lawrence didn't have an affirmative duty to go find all that. And as if Ms. Lawrence didn't go do that, because we have the testimony stating that Ms. Lawrence was copied and others from the Corporation Counsel asked Ms. Paul and others to collect documents from his case and to give them to Ms. Yu. And the documents that were in there and others that we now have, for some reason were not given to us, even though they should have been, as has already been ruled. So for there to sit there and say that we're harassing Ms. Zillig, in fact, Ms. Lawrence didn't do her job. The county didn't do its duty. And that's why we're here today, wasting more time. This is all on the county. Again, for not, we're here today, not ready to go forward, wasting everybody's time. Mr. Lucky is again, I mean, he's gonna wait months now because they refused to confer. Okay, we sent them weeks ago emails saying, when do you want to meet? Who do you want to go? And now she's sitting there saying the first time she heard about this was on Friday. So again, I read out the emails from me to her, besides having shown them to you before, saying that she knew that these things were ready to, what and who we wanted to hear because of the nonsense about buyers. We were very clear that we wanted to hear, and I'll say it, gosh, for the 8th time now, we wanted Novotny, we wanted Zillig, we wanted Ball, we wanted Paul. So she's here, she's ready enough to make a motion about that, but she's going to pretend like she never heard until a Friday for the first time who it is that we expect to go. And that's the bridge that's just too far here. Because everybody knew what it was. And that's when you look at the emails, it's going to be clear. We all knew what we were about for today. Recalling our witnesses and getting done what should have been done in the first place had we had the documents that they gave to us. Only after they were caught in order to do so. So for her to accuse us of harassment is factually inaccurate. It's the best that can be said about it. We are all here today wasted more time and wasting more time because of the county. And we keep bringing this up because it keeps coming out of this man's end. So they're trying to put, again, their failure to confer, their failure to respond. And this is, if we leave here today without a direct order to Ms. Lawrence ordering her to respond to our requests for information on, or to confer, we will just be in the exact same situation 2 months from now, except Mr. Lucky will be 2 months later, justice delayed. So there'll be nothing. I mean, she's already been ordered to confer, she just didn't do it. So what can we do now to ensure that we can be ready to go in 2 months from now with actual witnesses here? Because she's just going to say the same thing again, that nobody told her anything. But I mean, we sent you the emails. What more can we do than to say we want these people to show up on this date back on February 11th? And then she goes to you and you respond, but then she doesn't have to do anything. I mean, what more can we do? We do what we're required to do, and we get punished here. I just have one more thing I want to say on this, because this is the theme whenever you deal with the county, especially in Mr. Lucky's other actions with the county. They have every benefit in the world. They have an army of attorneys. They have a big budget. They have a corporation with employment powers. They have sworn law enforcement officers to investigate their cases for them and arrest people who don't tell them the truth. Mr. Lucky has none of that. And yet they still cheat. And yes, I'm saying cheat, because it's cheating when they go to you and say, without conferring. It's cheating when they don't respond. It's cheating when they go and talk to circuit court judges without telling me about it. It's cheating when they go and kick out the head of the PRB, because the president of the PRB and the vice president of the PRB, because they want a ruling to go a certain way. That's cheating. They have every power in the world, and yet they cheat. And the ERD has had time and time again opportunities to call them out on their cheating. And what does it do? It rewards them for cheating. And lo and behold, they continue to cheat. I think we've communicated.
Thank you. Ms. Lawrence, did you have anything else that you'd like to state?
Your Honor, I believe it's their case. I guess to prevent this exact same situation from happening at other times, I'm asking Mr. Hitchcock Cross to please list with specificity all of the county witnesses that he would like available. He has said he would like Sheriff Ball, Molly Zillig, Mary Paul, and James Novotny. If he can confirm that that is the extent of his list, we will certainly work on that to the extent that Your Honor orders them. Obviously, the county objects to recalling Ms. Zillig and Sheriff Ball based on their prior testimony that they don't have personal recollection or knowledge regarding these affairs. And I think if we can get that clarity on the record, we can make some progress here.
Right. So again, I guess we're in the 9th time here. We want all of those witnesses that we listed with specificity several times between the interregnum. And we want all of the witnesses that we subpoenaed, that they're aware of, because we put them on our witness list and subpoenaed them, available.
If I may, are you finished, Mr.
And
Hitchcock?
because they're not here today, they're subject to civil sanctions to Mr. Lucky for their failure to appear. We all knew that we had a hearing date today. The fact that they refused to respond doesn't change that fact. And again, their solution is for us to be ordered to do what we already did. I've read out, I mean, time and time again here, we told them the witnesses that we expected to have to be recalled. We also discussed that there was other witnesses that were not Miss Byers who should be available to testify today. They responded with 0. So
Okay.
To be clear, Your Honor, I'm not sure who these other witnesses are, which is what I'm asking for. I don't know of other subpoenas. I can't recall any other subpoenas. We're not aware of any other subpoenas. So to the extent that he needs me to make other county employees available or determine their availability, I actually need names.
We will be happy to provide them with names, but we cannot make
Yeah.
them respond. So that we will be, if that is what's required here, if that may, if that's the grounds for them not responding, we're more than happy to resolve that impediment.
Thank you.
Is it
Okay.
possible to get that on the record, Your Honor?
Do you have those names right now?
We'll confer as
You'll
normal.
confer. Okay. All right. Well,
Your Honor, I would ask, are all of the emails going to be made a part of this record then?
yes, I guess they should be since they were referenced here.
Thank you.
Okay.
Yeah, we will say that we have not subpoenaed the tech person, but since that issue is now on the record, I think if these videos exist, Judge, this case will be resolved on those videos one way or the other.
All
So
right.
let's get clarity on that. And if they were destroyed, let's get clarity on when they were destroyed.
All right. Okay. All right. So when we meet again in May, we will have had the benefit again of the two of you conferring with specificity which of the county employees you expect to see Attorney Hitchcock Cross and be available for testimony. And in the meantime, I will do my best to respond to your motions as I understand them.
Great.
And certainly if you wish to send me anything additional, you may.
Appreciate that. Thank you.
But I think I've got the gist of where you're coming from. And to the extent I have not been clear, I apologize for that, and I will do my best to remedy that situation.
Thank you, Judge.
Okay. Anything else that we need to address, Attorney Hitchcock Cross?
No, thank you.
Attorney Lawrence?
I have a few questions, Your Honor. First, what
Yes.
are the hearing dates that we'll be using in May?
Well, I have the 22nd through the 26th set aside. And I know that the county needs some of that time to present its case. So perhaps you and Mr. Hitchcock Cross can communicate how much time during that week will be necessary for each side.
Additionally, I'm sorry, Your Honor, please.
No, go ahead.
I was going to ask that we receive subpoenas for these the witnesses that Attorney Hitchcock Cross wishes to call. That way there is no mistake and absolute clarity when we return. I'm happy to help coordinate dates and times, but I think we need to be very clear as to who he intends to call when we return. So if he could send subpoenas for those employees.
There's no reason.
Greatly appreciated.
Absolutely no reason for that. We'll confer with you and we'll be clear. We've subpoenaed these people by giving them subpoenas directly, and we're not going to have an additional burden placed on Mr. Lucky.
Well, I don't think that's gone so well. We would ask that they be subpoenaed for the
Well,
hearing
what
dates.
hasn't gone so well is the failure to respond. That's what hasn't gone so well. There hasn't been any issue on our end. We have responded to all emails, and we have tried and attempted to confer. So again, we're not having this be put on us. We've got clean hands here. So we're not going to accept any additional burden. I mean, if the court's going to order it, then that's a different story, but absolutely not. You need to take, I mean, no. we've gone over all of the reasons why your conduct has gotten us here to this position here today. And again, one more time, you're trying to put it on this man here. So my feeling is that we'll follow the law, and maybe that would be a good place to start, and then we can go from there.
So I'm not going to require that they be resubpoenaed, but I do want to be perfectly clear that Attorney Hitchcock Cross will list out exactly the individuals that would be subject to subpoena.
Sure, and we're happy to do that as a courtesy, and I guess that's what you're requesting. That's no problem. In no way does that indicate that that's something that we should have done, or that that is in any way an out for the county's behavior here today. Those witnesses were all subpoenaed, and we already continued that from the last hearing here. We, as a courtesy, we are more than happy to assist that for clarity's sake. But again, you can only lead a horse to water. You can't make him drink.
I understand, Attorney Hitchcock Cross, and I appreciate you specifically identifying those individuals. That will be most helpful.
Great.
Okay, Attorney Lawrence, did you have something else?
I apologize, but also in addition to who he calls, I also need to know when he's calling them. I can't have everybody available for days on end. So if he could provide what date and order he'd like to call them in, that would be very helpful on the county's part to help make these arrangements. Also, Your Honor, are you ruling on the county's objection to recalling Sheriff Ball and Ms. Zillig? Or issuing a written opinion on that?
I'll issue something in writing, and I'll do it relatively soon. I will not spend an infinite amount of time waiting to do that.
So again, we are more than happy, and just to back up 1 second, at the beginning of all this hearing, I reached out to just numerous witnesses to schedule their time. I reached out to Ms. Zillig, in fact, in addition, to schedule her time. Ms. Lawrence said that she was a represented party and refused to allow me to contact her. I then tried to confer several times and called Ms. Lawrence several times in order to try to figure that out, because I understood these people were highly placed public employees. So again, we already did that. But as a courtesy and to hopefully to, let's say, the way that we look at that is that we're just going to eliminate another excuse for the county. So we are absolutely happy to provide them with the date and time of everybody that we'd like to have and when we'd like to have them, as we did back before the original hearing. So you can lead a horse to water, but you can't make him drink. And it's absolutely inappropriate to try to order us to do something that we've tried to get them to do in the first place. So the burden, it should be, what we needs to happen here is an order for them to respond, because that's been the failure, not from us to come to them with the information and try to confer with them. We've done that. We've gone above and beyond. They have straight up refused and have not responded. And again, they're trying to put a burden on us based on their bad actions. That's objectionable.
Okay, well, I think it is, well, it should be clear that if Mr. Hitchcock Cross reaches out with information regarding when and who will appear, or who and when, that be a subject of discussion between the two of you and a resolution with an understanding before we come back to hearing.
Thank you, Judge.
All right, anything else?
Not from us.
All right, well, I appreciate your time today. I apologize again for any problems that I've caused in this matter. But we will resume in May, and in the meantime, hopefully some of these matters can be resolved in and of themselves, and we'll go from there.
Thanks,
All right.
Judge.
Thank you for your time.
Thank you.
Thank you, Your Honor.